Appeal in the 4th District of the State of Florida is now in session. The Honorable Harvey L. J. Judge presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning, everyone. As you just heard, my name is Harvey J., and I have the privilege of presiding this morning over our three oral arguments. I also have the honor of serving with two of my esteemed colleagues, Judge Rand Wallace from Seminole County, and a longtime 5th DCA judge, and a longtime trial judge. Again, to my right and to my left, Judge John Harris from Brevard County. Again, a longtime 5th DCA judge and a longtime trial judge and former chief judge of the 18th Circuit. So it's really a privilege for me to serve with them today. We should be pretty straightforward as far as our way of going about things. Typically, for the appellant, we will assume 5 minutes of rebuttal time, and that will typically be the case for all unless we are told otherwise. It's also our plan to break after the second case, probably 5 to 10 minutes between the second and third cases, and unless we hear a reason otherwise, that will be the plan. Having said all that, are we ready to proceed on our first case?
Yes, Your Honor.
All right, you may approach, and for the record, that's case 23-2485.
Good morning, Your Honors, and may it please the Court. My name is Andrew Greenlee, and I'm here on behalf of the borrowers, Mr. and Mrs. Velasquez.
And Mr. Greenlee, 5 minutes for rebuttal.
Yes, Your Honor, thank you very much.
All right, you may proceed.
Your Honors, the defense moved for involuntary dismissal at the close of the lender's case in chief. At that point, there was no evidence whatsoever in the record regarding the amounts due and owing. The trial court was duty-bound to grant the motion for involuntary dismissal.
What about the promissory note? I mean, there was a promissory note that was not canceled, and as I understand the case law, that's a good enough thing according to several DCA cases. So why was the court wrong here?
Your Honor, I don't mean to quibble with Your Honor's research, but the case Wolkoff, which is one of the leading cases on the amounts due and owing and whether involuntary dismissal should or should not be granted, in that case, the promissory note was introduced into evidence, and the appellate court said that because there was no evidence regarding the amounts due and owing, involuntary dismissal should have been granted.
Well, and we do have a somewhat unique situation here. We have an interest-only 10-year, first 10-year note. Was that case an interest-only 10-year note?
Your Honor, I am not aware of what exactly the security instrument that was used in that case.
Wouldn't that make a difference? Because if obviously there is some payment on principal, I get it. But here we have a note that, as I understand it, it's undisputed was a 10-year interest only. We were still within that 10-year period as far as payments, so we would know precisely what the principal was due and owing.
Well, I disagree with that. It's a little bit more complicated, Your Honor.
What do you disagree with respectfully?
Well, the part of it, well, the breach date that my friends on the other side have alleged was a 2013 breach date. And so there were payments that were made on the mortgage. That much is undisputed. The amount of the payments, there was several kind of breaks in things. You know, there was an initial foreclosure action that was subsequently dismissed. Then we had the bankruptcy, and the borrowers agreed that they would continue to make payments. The amount of payments that they did make, it's not known from the record how much they were, how many payments they made, and what the principal that was due. It might be a different case, Your Honor, if there were some sort of...
Let me stop you there, if I may. Is that not your client's affirmative defense to prove payment? Again, as I understand the law, I mean, I think payment is an affirmative defense.
We are of the position that the amounts due and owing is an element of the plaintiff's case. And again, I would refer Your Honor to the Wolkoff case. Even their lead-off case on this issue, Deutsche Bank versus JB Investments, they say to establish, and this is a quote, to establish a prima facie case, the plaintiff must prove the amount due. Again, I mean, what we have here in this case is a trial court judge essentially making up a breach date, and that everything kind of flowed from that breach date, and there's simply no evidence to suggest that the breach date occurred in December of 2007 as the trial court held.
What do you make of the fact, I believe your client submitted an affidavit in opposition to the motion for summary judgment where your client, one of your clients, indicated that the breach date was October of 2007. I mean, what do you make of that? If it was, I mean, to use what you just said, it was unfair to your clients to use a December of 2007 breach date where you have one of your clients saying the breach occurred in October of 2007.
Yes, Your Honor, that was not evidence that was submitted as an exhibit in trial. Summary judgment is not a substitute for trial, and you know, when you proceed to trial, you have to be prepared to prove your case. An element of their case is the amount that's due, and there was simply no evidence presented regarding the amount due. Typically how this is done, Your Honor, is there is either, you know, a payment history, some documentary evidence, or there could be testimony from a competent witness. Again, returning to their case, their lead-off case, Deutsche Bank versus JB Investments, there was a partial payment history plus witness testimony. So they had two different ways, the witness testimony regarding the amounts due and owing. So that's the case that they rely on for this. There has to be some evidence of the amounts due and owing, and that is a far cry from what we had here, Your Honor, where there was no evidence whatsoever. It was bereft of evidence.
Would you agree, Mr. Greenlee, there are cases saying that if you have a promissory note that has not been canceled, that is a good enough thing? I mean, there are cases that say that. You would agree with that?
I've read the cases, the authority they provided. For one thing, they're quite old. They're not in the foreclosure context. I mean, one is from 1959, I think. The other case is from 1971. These are, you know, I'm no spring chicken, but these were decided before I was born. Another point of distinction, Your Honor, is that these cases are, or this particular, in the mortgage foreclosure context, there are monthly payments, month after month. Those cases are just a promissory note. Like, you make a loan, and it wasn't paid off, and you know, payment of the note, yes. So if you can say, I've satisfied the note, that's an affirmative defense. That's not what we have here. We have an installment contract where some payments were made. Again, my friends on the other side, they pegged the breach date as, and this is in their affidavit, as February 1st, 2013. So what happened in the intervening time? You know, from 2006, when the loan was originated, to 2013, nobody knows. Nobody knows how much money went into the bank, how much went to principal.
Well, there was an attempt to present evidence that was excluded.
Yes, yes, Your Honor.
And if that evidence was wrongly excluded, you would agree that evidence proved what you're saying should have been proven, or not?
I disagree, Your Honor. For one thing...
And just so I understand what you just said back to my question.
Yes.
So you're saying even if the evidence that they had proposed had come in, that was still not enough?
Yes, Your Honor.
What was deficient as to that evidence, the proposed evidence?
Right, okay. So the proposed evidence, they said that the evidence was the evidence that was presented in the summary judgment motion. So if you look at that, there's number one, there's a HUD statement that's from the origination of the mortgage. That's the first exhibit. And number two, there's a one-page payoff/paydown quote. And the third is other HUD forms. Again, these are dated from 2008. So none of those, the payoff or paydown quote was prepared in anticipation of litigation. There was no underlying documentation. It might be different, Your Honor. I might agree with you if there were a payment history that were attached to their summary judgment evidence, but there was simply not. And I will say, Your Honor, I'm glad you brought up this point because, and this goes to their cross appeal. Number one, it was properly excluded because it was untimely. It was 9 days before a trial. If you look at the case management order, and that's in the record at page 576, it requires that any fact witnesses must be disclosed 45 days in advance of trial. So they're coming in with essentially a surrogate for a fact witness, an affidavit that was filed 9 days in advance of trial. Also, the case management order provides that 30 days prior to trial is the cutoff for discovery. You can't cross-examine an affidavit. So, there was no time to conduct any depositions, nothing. It came out of left field. It was a surprise to my clients and to trial counsel. And I think the trial court judge properly excluded it because it was untimely. Now, if you look at their business records or their pretrial statement, where they announced that they intended to rely on this business record certification, they also say that there is like a payment history. So one of their proposed exhibits was not included in the summary judgment evidence. So again, I mean, this is, it's unfair surprise. It was untimely. In addition to that, as the trial counsel noted, he had no opportunity to inspect the underlying documents, right? So the payoff statement, the one-page payoff/paydown statement, which is where the amounts due and owing would have come from, again, he didn't have, that's just essentially a summary exhibit. This is how much they owe. It's a one-page statement. But without the underlying payment history, there's no way of examining where those figures came from and effectively rebutting that at trial. So again, we were surprised by this disclosure of the business record certification. Even if the records attached to summary judgment were introduced at trial, it would still be insufficient because that one summary, essentially the payoff/paydown quote was a summary exhibit and we didn't have the underlying documents. And so even if that stuff had been...
Let me ask you about
Yes.
that. And I appreciate what you're saying, Mr. Greenlee. You didn't have the underlying documents, but that summary statement, would that have been a good enough thing? Assuming the court should have allowed the summary statement to come in, would that have met their burden?
Well, I don't think so, Your Honor, because it's not a business record. It's a record that was produced in anticipation of the trial, and so it wasn't something that was kept during the regular course of business. So I don't think that would have fallen within the purview or...
So you would say that would be hearsay?
I would say it would be inadmissible hearsay. Yes, Your Honor.
If it was not hearsay, would that evidence have been enough to get them over the threshold?
Well, we don't, from a procedural standpoint, we don't think so because it's, in effect, it's a summary exhibit and it hadn't been properly disclosed.
And I understand that that's the argument, and that's the reason the court excluded it.
Mm-hmm.
But I'm just saying if the court wrongly excluded it and it was admissible, would the evidence in that summary have met their obligation of proof against your clients?
We don't think so, again, because there was, if you look at the document, I carefully examined it this morning, it doesn't list any affirmative breach date. And so without the breach date, yes, it says that this is the amount that's owed, but again, it's our position that that would not be sufficient in and of itself to carry their burden regarding the amounts due and owing. With regard to our second argument on appeal, Your Honors, there was simply no explanation for the disposition of the laches defense. This is not a case where where laches couldn't possibly be at play. There was a 10-year delay in between when they claimed, well, there was a 10-year delay since the dismissal of the prior foreclosure action and this case, and so in the intervening time, I apologize, Your Honor. I want to correct that. I believe there was a 6-year delay from the dismissal of the prior foreclosure action. And in that intervening time, so 10 years in total, during that 10-year gap, there was, number one, delay, and number two, there was a loss of evidence that was necessary to contest the amounts due and owing.
As I understand that defense, laches, that's an equitable defense.
Yes, Your Honor.
And so that's, again, within the equitable powers of the circuit court. And it's your position, your client's position, that the court violated its equitable function by not finding laches in this case?
Not quite, Your Honor. And thank you for allowing me to clarify that. The trial court violated the summary judgment rule, because if there is an affirmative defense and there is once the defendant has kind of established his initial burden of showing the applicability of the defense, it still has to be rebutted and disposed of by the court. So the trial court it pretended like laches didn't exist. If you read the summary judgment order, they talk about other affirmative defenses like statute of limitations, but there is no mention. If you do a keyword search of laches in the summary judgment order, you're not going to find that word appear. So again, on summary judgment, it's not enough to say there are no material disputes of fact. You actually, under the rule, you have to state the reason on the record for why summary judgment is appropriate, and without any explanation whatsoever regarding laches.
So just so I understand, and we're close to your 5-minute rebuttal time, you're saying there were genuine issues of material fact as to the laches defense?
That's exactly right, Your Honor. If it's true that my client lost documentation that was necessary to defend the actual case, and there were several kind of components to that, several moving parts. One is documents that were necessary to prove the amounts due and owing. The second part of it is documents related to the statute of limitations defense, where my client took the position that the loan was never decelerated. We know as a legal matter, once the dismissal of a foreclosure action occurs, the parties are supposed to be kind of placed in the status quo ante. But if actually if that doesn't happen and there is no deceleration, it's our position that that also is a material dispute of fact that should preclude summary judgment. One final point, Your Honor, and I understand I'm in my rebuttal time. I'll live with that. I know we didn't properly preserve the last issue on appeal, the bias of the judge, but it's extremely troubling that a trial court judge would, before even hearing the basis for a motion, would just announce that it's denied. I know where you're going with this, it's denied. There are serious due process problems with a trial court judge behaving in that way. And while it might not be properly preserved, I do think that it's germane to whether or not my clients received a fair trial and a fair hearing on their arguments before this judge. Thank you, Your Honors.
Thank you.
Good morning. Good morning, Your Honors. Eric Levine here for the Appellee Cross Appellant Wilmington Trust. May it please the Court. The final judgment of foreclosure entered in this case should be affirmed. The appellant has outlined several issues, and I will go through each one point by point, but with brevity. So involuntary dismissal.
Let me start pretty much where he ended on the laches defense, laches affirmative defense. I read this judgment, summary judgment order, and there's no reference to laches. And as I understand what the rule requires of the trial judge, that needs to at least be addressed. What say you as to that purported deficiency?
So the current summary judgment standard, not really the new one anymore, but 1.510 says the trial court must state on the record, which could be at the hearing or in the written order, that the reasons for granting summary judgment. I have not seen any case law that specifically says you need to point by point address every single detail of the arguments, and if you don't.
So your response, just again, so I can understand it, the panel can understand it, is it may have been a good enough thing just to verbalize on the record as opposed to putting it in the written order. Now, do we have a transcript of this?
There is a transcript from the summary judgment hearing. It starts on page. It's blocked off a little bit, but it's in the record.
So was there a mention of that by the judge in the transcript?
My memory is not telling me that the word latches was maybe specifically addressed at the hearing, but in any event, if you look at the summary judgment order and you look at the required elements for latches, it clearly addresses this situation. Because latches requires not just delay, it requires somewhat of a representation by the plaintiff, I'm not going to enforce my rights. So you can somehow reasonably rely on that representation, sit back and not do anything, and then, oh, I'm surprised and prejudiced. But as the counsel mentioned, there was a prior foreclosure action. Where is the representation by the plaintiff, we're not going to come after you, we're not going to pursue our legal rights? It doesn't exist. It's quite frankly the opposite. Second, latches needs to show prejudice. Somehow you're prejudiced by this delay. Now, in foreclosure cases, case law has been clear that because you get to stay in the property longer, you really don't have a prejudice by the lender's delay. And the prejudice he identifies is, well, documents we need have disappeared. What documents? You can't just come into court and say, there's documents that I had that I don't have anymore, so I should get past summary judgment. No. What are those documents? What would they say if they were here? I think the only thing he ever kind of identified was he says that maybe there might be a letter from a prior servicer, I think SunTrust, that he thinks accelerated the loan. But SunTrust still exists. SunTrust merged with BB&T, now Truist. Third-party discovery on SunTrust might have found that letter, never did it. And even if there had been such a letter, when the prior foreclosure action was dismissed under Bartram from the Supreme Court, under this court's decision in Grant, that acceleration is nullified. So there's no statute of limitations defense, viable one. There's no latches defense viable because in addition to the argument I made about prejudice, Florida law said that if your action is timely under the statute of limitations, which this action clearly is, you can't have latches unless there's really strong equities that allows a plaintiff not to proceed with an action that would be timely under the statute, and that just doesn't exist here.
Isn't that quintessentially something that is determined by the fact finder as opposed to something that would be determined on summary judgment?
Only if there's a disputed issue of material fact that requires a trial. And that's what's interesting about the entire argument he makes about the default date and the amount due. As Your Honor pointed out, on summary judgment, he put in an affidavit saying, Mr. Velasquez said, I stopped paying in October 2007. Why would we even have to go to trial on the initial date of default? It's not a disputed issue of fact. It's been fully admitted by everyone. The trial judge, it's a different trial judge than the summary judgment judge, but the judge who entered summary judgment accepted that representation, said, I find a continuing state of default, including for the month before this action was filed, and then he says, well, there's documents regarding the amounts due. Amounts due. Remember, we didn't go after escrows. This was simply principal and interest.
And you just said continuing state of default. Is that something part of this court's calculus algorithm in evaluating the laches defense? Does that matter?
I would say it does. I'm sorry. It matters because it proves laches doesn't apply. Because every month they don't make a payment, our cause of action renews. So was there a delay between the December 1st, 2007 default date and the, what was it, January, I'll get the exact date, January 26, 2018 complaint filing? There was only a couple of weeks between the two. So laches doesn't apply here. It very rarely, if ever, applies in a foreclosure case because you just can't prove prejudice from getting to stay in the property, which I don't know if Mr. Velasquez and his wife are still in the property as of today. I can't make that representation. I'm not sure. But they certainly were still in it as of 2023. So that's 15 years or so or more where they were in there without making payments. And he talked about documents about how much he needed to calculate the amount due. That makes no sense to me. If he admits he stopped paying in October 2007, and we all, as you say, from the face of the note, interest only for the first 10 years, we all know that the full $348 was still due in principal when he defaulted. And it's a fixed rate note.
Is there any evidence in this record that any payments were made toward principal in this case?
In the trial evidence or at all in the entire record?
In the record, in the entire record.
Yeah. Oh, towards principal?
Yes.
No evidence of any principal payments were made because they weren't. He made payments from December 2006 was when the first payment was due, until October 2007. October 2007. That's the true payments. 10 payments. Interest-only period, the principal balance never moved, and using a calculator, and if you needed an amortization schedule, you could do it just by simple math, but using elementary school arithmetic, what's $348,000 at what, 5.7% interest for 20, since 2007, 15 so years, that's just math. And the court can do math. They're allowed to do that without testimony. You just put it in the evidence. And so here...
Well, the other feature there, though, assuming the principal is the principal and no principal was ever paid upon by virtue of 10 years of an interest-only note, what about the prejudgment interest? I mean, obviously that was a feature of the court's judgment. When you start matters on prejudgment interest?
So, two answers to that question, because their argument, both at trial and their appeal, is slightly different, and they kind of confuse two issues. When it comes time for involuntary dismissal, not competent substantial evidence to sustain the judgment, but has the plaintiff proven a prima facie case, giving all inferences to the plaintiff, everything assumed true, all the plaintiff needs to prove is 1 penny. As long as there's evidence that 1 penny is still due, involuntary dismissal is denied because you've shown entitlement to a judgment for 1 penny. Now, that's an extreme example. So here, he made the argument, not Mr. Greenlee, but the trial counsel made the argument to the trial judge, Judge, we don't know the exact date of default, so how can you calculate prejudgment interest? And the judge said, and I think it was page 1102 of the record, she said something along the lines of, well, that doesn't dismiss the whole case. And she's absolutely right. Because even assuming the plaintiff's evidence, just limited just to the plaintiff's evidence, proves $0 in interest, which I disagree with, but let's give him that benefit. We prove principle, and once we prove principle, involuntary dismissal is denied. At that point, the defendant had a choice. He could have put on a defense case, or not. They chose to put a defense case on. The defendant chose to testify. He testified he paid for about a year, which is honest. He did pay for about a year. And the judge took that testimony and said, I'm accepting your testimony. You paid for about a year. I'm giving you the December 2000 default date, which is actually better than with the reality. And I'm calculating interest from there. Now, trial counsel objected, said, wait a minute. Their complaint only pays interest from 2013. How can you give them from 2007? And the trial judge said, well, you objected to their evidence, showing they only wanted interest from 2013. And she even said to him, basically, I'll give you a choice. Either let the evidence come in, which is beneficial to your client. Your client's better off if their evidence comes in because then they are only getting interest from 2013. Or I'm going to go with what your client said and award interest from 2007. And trial counsel basically said nothing. I basically agreed. Didn't agree. Said, I'm not doing anything 2007. That's what the trial judge did. And that's the exact role of a trial judge sitting without a jury, hear the evidence, weigh the credibility, and make reasonable inferences. And a reasonable inference from Mr. Velasquez's testimony that I paid for about a year is about a year. October 2006 to December 2007. This is exactly what a trial judge is supposed to do. And so involuntary dismissal was properly denied. The judgment that actually entered was supported by competent substantial evidence because it's based on the principle of the note plus interest from 2007. No affirmative defense was shown to avoid summary judgment of imposition of an equitable lien. And I want to talk about, because I got 10 minutes left, but I want to briefly talk about the cross appeal. I don't think the court needs to reach the cross appeal because this is just an affirmance as the judgment has already entered. But if for any reason the court thinks there has to be reversal here, reversal has to be for a new trial because the evidence that was offered was improperly excluded. Now, counsel said 30 days or 45 days, but he's overlooking the actual trial order. It's on page 855 of the record, paragraph 3E. Five days before trial, you have to disclose your exhibits. 9 days is more than 5 days before trial. And the other thing he didn't really explain to the court, and I'm not sure if the court understood, is the underlying documents that we were relying on, that was our summary judgment affidavit that had been in the court file for 10 months. It was the same affidavit that the court accepted on summary judgment. So when he says, well, this is out of the blue, we had no opportunity to take discovery, that's the summary judgment affidavit filed in August of 2022. 10 months to depose the summary judgment affidavit, 10 months to probe the validity of the documents. But we were just using it to show the amount due, but the amount due, we don't need it. It's $348 plus interest rate 5 plus a fixed rate of interest. We don't even need those records. So, but in the event this court decides a reversal is necessary, which I don't believe it should be, then it's should be remanded for a new trial, at which point we could put this in evidence. We can put the summary judgment, Mr. Velasquez's summary judgment affidavit in evidence, because that apparently is he thinks that's necessary after the fact. But we don't need to waste the court's time or the trial court's time with a remand. I think this should just be an affirmance. So,
Mr. Levine, can I ask you a question?
of course.
Kind of a follow-up to Judge Jay's question about deferring to the trial judge, weighing the equity. You mentioned the credibility. Was there any question or genuine issue of material fact as to the marital status of Mr. Velasquez?
Marital status.
Marital status of Mr. Velasquez at the time the loan was secured?
I don't believe there was. I mean, I think this gotcha that he pulled when he said, I'm buying a house, and I don't think I have a copy of the mortgage printed, but I believe he wrote on the mortgage unmarried, which is why we only had him sign. But let me not make that representation. I just don't have it in front of me. I don't think there was a dispute. I think we all accepted he was married at the time. He wasn't honest with us when he got his loan, and that's why we have an equitable lien. So no, I don't think that was ever a disputed issue of material fact, just like the date of default was never actually a disputed issue of material fact until suddenly he wants to move for involuntary dismissal, and for the first time ever, well, we don't know when I defaulted. We all know he was never in dispute.
Well, and I think there was mention, and when Mr. Greenlee was giving his presentation, there was used interchangeably the parties making payment on the loan, versus party versus defendant versus defendants, plural. Was the record evidence in the trial court that the parties, plural, both Mr. and Mrs., were committed to the process of paying whatever payment history that you have, or was it singular payment?
So the note and the mortgage are only signed by Eddie Velasquez. That's certainly true. I know they both filed bankruptcy, and they both have a bankruptcy discharge. Now, our position is, because it's the only legally correct position we can possibly take, is Ms. Velasquez is not obligated under this note. And if she herself was writing checks to make the payment on the mortgage, the record does not reflect who the payments are coming from. Only thing that the evidence reflects is there were only 10 of them until October of 2007. But, I mean, obviously, if we have a remand, we could put bankruptcy at court evidence into before the court, but I don't believe that's necessary. So, unless there's any question, I would ask that the final judgment of foreclosure be affirmed, or in the alternative, the court believes that a reversal is required. Reversal should not be for dismissal, but it should be for a new trial or further proceedings as the trial court would elect. Thank you very much, Your Honors.
Rebuttal, Mr. Greenlee?
Thank you, Your Honors. First, I'd like to correct the record. My client did not testify that it was about a year. He said well over a year. And as trial counsel pointed out, well over a year could be 4, 5, 6, 7 years. Regarding the amounts due and owing, it's simply not the case that if you...
But to that point, Ms. Greenlee, is there any evidence that was more than 10 years?
No, there's not. There's not evidence one way or the other, but again, it's the plaintiff. They're the one coming into court seeking a money judgment, and you can't just make it up. I'm sorry. You can't just say, well, I think that the breach date is, December of 2007. There has to be evidence of the breach date. I mean, we're in a court of law here. They're asking for a fixed sum of money, and even if it is true, as my friend says, that, the principal remains outstanding for 10 years, what about the interest? I mean, there was over $100,000 in interest awarded here, right? So the breach date, surely the breach date is germane to that. And they didn't carry their burden on that. Again, the representation of my friend on the other side regarding the trial order, paragraph 2 says, all dates in the CMO remain in effect. So it incorporates by reference all the deadlines in the case management and scheduling order. All the trial order says is you just have to have a pretrial statement that lists all these things that should have been disclosed during the course of discovery.
What about his point, and I think it was one of his last points, that it was in the court file for 10 months ahead of this trial and that there was no surprise because it was already in the court file? What do you say to that?
Well, number one, we didn't know that they were going to rely on that. I mean, that was, summary judgment is its own discrete and distinct phase of the proceedings. We had no notice that they were going to rely on some affidavit from a year ago regarding what would or would not be presented at trial. Had we had the notice, had that been disclosed in advance, You know, within the 30-day discovery deadline, we could have scheduled a deposition with this gentleman. You cannot cross-examine an affidavit. There's no way of contesting the amounts that they say in this payoff paydown statement. We had no way of contesting that. The other thing is, I'm informed by trial counsel that in Seminole County, there's only one foreclosure judge, and it's done at intervals of 30 days, and they only hear foreclosure cases once every 30 days. So we couldn't have any reasonable time to move to exclude that evidence and get it set for a hearing and then have everything proceed in advance of trial. It was simply too close to the date of trial. It was untimely. It was properly excluded. Regarding the delay, look, I mean, we all know that by conduct, it's the same thing as a statement. So if you sit on your hands for 10 years when you should be filing suit and pursuing your rights, that's textbook latches, right? So I'm not sure with this notion. Yes, it's true that delay standing alone in the foreclosure context, I mean, I think that's a sensible rule. If you get to stay in your house, delay alone can't be prejudice. But here we have delay, and we have documents that my client was, and he specifically referenced documents, you know, mortgage statements, the origination documents, the breach letter. None of those documents he had in his possession, and those were necessary for him to defend the case. So we have delay, plus we have prejudice in the form of the loss of documentation. That should be enough, at least to make a prima facie case that the trial court has to at least acknowledge it and dispose of it on summary judgment. And having failed to do so, Your Honors, the trial court committed reversible error. We would ask the court to remand for the entry of involuntary dismissal. Thank you.
Thank you. Thank you both. It was well presented on both sides.
Thank you.